everyone. Hello, girls. Hello, girls. It's really nice to be part of this meaningful project and online program. I hope to give you a little bit of an insight of something that really matters a lot for your projects, your ideas, and maybe even your future businesses. So we'll step into the world of intellectual property, or you may hear me call it IP. And by the end, I hope you'll understand what IP rights are, how it protects your creations, and also what it does not protect. So at this stage, of course, I would like to say that, of course, you can ask me and you can interrupt me at any time. You just remove the microphone restriction. You just speak, because perhaps I won't be able to see if you raise a hand or if you open your cameras, because I will be focused on the slideshow. So you can just tell me, Rita, please stop. Oh, of course, I forgot, totally forgot. My name is Rita Galides. I'm a corporate lawyer at a consulting firm in Cyprus. And I'm really excited about intellectual property in general. And I'm really excited to be sharing this information with you as well. So you can just call me Rita. Not Miss Rita, simply Rita. So if you want, we can discuss and we can, I would like to get to know you a bit more. Perhaps your name and what are your interests, or what you would like to study or aspire to become in 10 years' time. But if not, if you want just to be here and listen to me, I'm more than happy to do it. So I'll give you 10 seconds if anyone wants to say something now, or you can just interrupt me later on.
Hello, my name is Maria and I'm glad to be here. That's all that
Hello,
I want to say.
Maria. Hello, Maria. So happy that you're here as well. So if
I'm
you
one of
need
the shyest. I think it's really good to just open my microphone. I'm a bit shy person, but it moment give me some, I don't know, motivation to speak up.
Yes. So I used to be, and actually I'm currently are a shy person as well, so I can feel you. And by opening your microphone is a good start. So thank you. So I think we can move on. Can you see the change on my slideshow?
Yep.
Great. So let's start with a question, which of course you can answer in yourself. You can simply just think of that question on your own. You don't have to reply to me here. It's just a simple question to think about something cool you've created, maybe a painting or a story or a TikTok concept or a logo, or even an essay or a project that you're working in. Just think of it for a second. I'm sure you can imagine something. So now imagine if someone else comes over and you realize that they use that exact project or essay or painting and they call it theirs. And all of a sudden, they get all the praise out of it, and they get all the credit. How would that make you feel? I'm sure that's a horrible feeling. It's a feeling that something was stolen from you, even though it's not a physical object. I mean, even though it's not your phone, it's your idea that has been documented, and it was a process, and it was like a thing that you own. And this is why we have intellectual property, to protect that right per se. So, intellectual property, basically, because it's really important to have a basic idea and the basic definition of intellectual property. It's a creation of the mind that has some sort of a value. It includes things like stories, drawings, music, inventions, product names, logos. Actually, IP rights are everywhere. Intellectual property is everywhere. Wherever you turn, you can see an IP. So IP law and all the regulations that governs IP gives you rights over these creations, a bit like how you own a house. But here, you own your creative work. Now, why IP matters and why it should matter to you and to everyone. Actually, you should even care now that you're still at school, because as I mentioned earlier, it could also include essays, it could also include projects, it could include a painting, a drawing, a story that you created for a project at your school, or anything. So IP rights are available to everyone from the very beginning of their lives. So IP is very important because it helps you control how your work is used. It supports fairness and make sure you get recognition for what you have created. In the future, which is very important to have that in mind from now, if you launch a brand or a business, or if you create a game, for example, IP rights can help you stop others from copying that creation, and can even help you earn money from it. Because when something is registered under your name, you can very clearly and very fairly document it and have an evidence that this is mine. So if you want to use it, you can pay money to me. Simple. Let's move on. So, an example of that, just to give you an idea, just since, I mean, I'm sure that you all have smartphones, or even if you don't have a smartphone, you do know that smartphones have the options to download applications and games on our phones, etc. So imagine that you study software development, and you develop a game, and you create an application for the phones, Android and Apple and anything else, and you sell it through that specific software coding and all that tech things that I'm not familiar with, but I know that these stuff are very well protected through IP law. And of course, you can then sell it through the App Store, through the Google Play, and you can even earn millions or thousands of euros out of it. but you can only do it if you protect it wisely. So, oops. Now, let's move on to the main types of IP. There are different tools under the IP umbrella, as I like to call it, and each protects something slightly different. So copyright protects the creative work that, let's say, of a writing, of an art, of music, of videos, of school projects or essays. Trademarks, on the other hand, protect brand names, logos, slogans. For example, if you go at a shop and you see their logo or the logo on the Nike shoe, this is a brand name. Sorry, this is a logo, which is protected under the trademark tool. Patents protect new inventions and technical solutions. And design rights protect the way a product looks, its shape or its style, its packaging. We will see examples of each of that IP tools separately in the following slides, so you get a better idea of what each tool is. And I'm sure that during your lives, you might use more than one of these at the same time. Or you might come across. So, copyright, the first very useful tool under the IP umbrella. We're starting with copyright because it's the one you're most likely already using without realizing. Copyright protects things like stories, poems, drawings, paintings, songs, projects, essays. The list is long. I'm just saying a few examples so you can get an idea. In many countries, copyright protection starts automatically as soon as you create the work and as soon as you save it or somehow record it or write it down. You don't always need to register anything under this tool to have a basic protection. But the most important thing to remember here is that copyright protects the expression of an idea, not the idea itself. And this is very important. So two people can have an essay written down about an elephant who flies, a flying elephant. The general idea isn't owned by anyone, but each specific story that is written by the two individuals is protected, provided that it's documented, so someone writes it down. So, copyright and your school projects. I'm sure you are very concerned about this matter, as you should. Now, anything written, like a report or a design, a code, a painting, anything related to a school project or any other project, can all be protected by copyright. You actually get the basic rights automatically when you create them, when you document them, and when you save them, or when you have a date on it, your name, etc. What really helps here as a proof that what you did and what you created is yours is saving drafts, keeping file with dates, and not deleting, let's say, early versions, because many of us, when we have the final version of something, let's say a Word document, we tend to delete the previous versions, but that actually won't help in that case, because each version has a date on it. So if you have, let's say, a disagreement of whether something is yours or not, the date will matter. The date that you created something will matter. And if someone comes over and shows that they have something created earlier than that date, and they can prove it, then you run the risk to lose your job, or to use the right over that work. So protecting it and saving it, keeping all the records. If something is important to you, keep all the records and all the previously and early versions of that thing saved in a drive. So here is just a visual with some examples of what a copyright is, just to memorize it more easily. At least that's how my brain works. I find it a lot easier if I connect new information with a picture. I tend to memorize things better that way. So you can see here some books, movies, songs, photographs, software programs, as we said before, with the applications, paintings. The list is very long. This is just the basic idea. So now, next is trademarks, the second tool under the IP umbrella. Trademarks protect things that show us where products or services come from. That's usually names, logos, or slogans. It's the most typical type of a trademark. And when you see, for example, a logo on a pair of trainers or on a phone, you know which company made it. That's the power of a trademark. And if you think of famous brands like Nike or Adidas or iPhone, of course you can recognize their logos in a second. So if you see a shoe, you can recognize it's theirs. And actually, it's very useful because trademarks help people avoid confusion. They stop another business from using a confusingly, let's say, similar name or logo for the same kind of product. And most of the cases, if someone tries to copy it, or even if they don't copy it, they make something really, really similar to it, they will have a problem, especially if you try to copy a very famous brand, which they have the money and all the resources to run after you. So here are some trademarks, and you will see some simple example of brands like Adidas, Nike, McDonald's, Rolex, Amazon. All these logos are well, you can recognize them at a glance, I'm sure. And it's really interesting that each of these names or logos are, of course, already protected as a trademark. And very interestingly, we do know what they represent, and that's the power of a picture and a logo and a slogan. You just see one logo, see one design, and it's there, you know. It's actually marketing, but it's protected marketing. And the companies behind any company, actually, behind the logos and behind the business, spend so much time building their brands, their reputation, their products, that of course you can imagine they wouldn't like it at all if someone else tries to use almost the same name and logo for their benefit, because it's a process to build a business. It's a process to make yourself and your business known. And if someone else comes and steals that from you, they have all the hard work, let's say, done for them. And that's unfair. So, moving on to the third tool, we have the patents, which are actually for inventions. They protect new technical solutions and things that actually do something in a new way. And to qualify an invention to qualify an invention, you need to prove that it's new, brand new, not obvious, and very, very useful. Protecting a patent usually requires a very long process. A lot of documents need to be submitted, and it's not always straightforward and easy. But of course, it's worth the try. And if you get the correct lawyers that are experienced and that can assist you with this kind of applications, you're good to go. You will be prepared in advance. Yes, an example of a patent. It could be a new type of a phone battery, let's say, a medical device, a new kind of machine, or a material. It's more relevant when you turn a project into a real world product or startup. So I think it will be very helpful to check here. So you can, of course, have some visuals to help connect the information with a picture. And because this is very relevant and very close to what we experienced a few years ago with COVID, the vaccines, of course, were a patent. They had new technology, the vaccinations, the COVID vaccinations for that virus were new. They had new technology in it. They were useful for the public, and they actually met all the criteria to be patented. And of course they were. Here we can see an airplane mechanism. I don't know exactly what that is. A phone application, the vaccines, it could be anything. Could be anything. Again, the list is huge. So the final main tool under the IP umbrella is the design rights, which protect how something looks on the outside. Not how it works, like a patent, but how it looks. They can cover the shape of a product, their color, and their overall visual style. If the look is original, it may be protected as a design. And this can be very important for fashion, let's say, tech gadgets, or even product packaging. So here, this is very helpful. The Toblerone, when I think of a design, I always think of Toblerone, the chocolate. And I want you to think of the shape of something that you own. For example, a Coke. Its bottle has different shapes and had different shapes over the years. Did you ever realize that each of that shape was actually protected? But if not, I can assure you that it was protected. The shape of the bottle itself, like Toblerone, like our smartphones, like our shoes, their shapes can be protected. And most of the famous brands that we see, they have already gone the process of that protection. And you can be certain of it. So I'm staying here at this specific slide as I want to raise another important matter here. Can you imagine, or can you think of whether, for example, Toblerone, the chocolate packaging, what kind of IP tools can protect this chocolate that we see here? Is it just the design of it, like we saw now? Or do you believe that any other tool can be used here? Just think of it for a second. If someone wants to reply, you can, or else I will give you the answer. So Toblerone, of course, the shape of it, the triangle shape of it, very indistinguishable. It's a design and it can be protected, and it is protected. And the name Toblerone, written in red, bold, big letters, is protected as well under the trademark tool, because that's the logo of the company. Not the shape of it, not the shape of the chocolate per se, but the logo they use so that they're distinguishable from other chocolate companies like Cadbury. So you can see here that for one product, you can protect it under several tools, under several options. It's also very important to check what IP does not protect. So you're aware of when you can step in and seek for protection, or whether you should wait a bit more and be a bit more reserved and private as in terms of your idea. So IP does not protect ideas that are only in your head. It does not protect very general concepts or themes. It does not protect inspiration or a style or a vibe or facts or general skills. Protection usually starts only when you turn your idea into something concrete. Write it down, draw it, paint it, record it, build it, have it somehow documented. Just ideas in the air, not protected. So saying that, let's go back to the example of the application of the phone app. If you say, for example, that I once had an idea about a study app, it's not enough for IP protection. But if you actually design the application, if you actually code it and prepared the coding and the software, and you developed everything that needs to be developed, then this, of course, can be protected. And it's an expression, let's say, of what you thought, of the idea you had. You actually expressed it through the software development that is needed for that application. So your ideas alone are not enough. So let's make it super clear with an example. Idea is the app that helps students swap notes safely. This on its own is not protected. The expression of the application, which is the specific app that was created and developed, the colors that you decided to design the application with, the logo that you chose, the data and the software coding that was needed, and the development of that is actually protected, can be protected. So, for example, for school projects, IP law looks at things that you actually write, your designs, your coding, as long as someone can see it. So if you talked about it in a classroom full of students, that's not protectable. I hope this is clear. If something is not
May
clear,
I ask you the one question? Sorry to interrupt you.
of course.
If it was copying, but not like fully copying, just change some details, but it's looking like copy, but basically it's not full of copy. They copy most of that, but change like the details.
Mm-hmm. So in that case, you're talking about something, I mean, was it a school project or an essay? I understand correctly, right?
Just take the example, an essay or a school
An
project.
essay.
That's
Okay.
the idea of the school project, but they change, or story of the book, but they change like just the name of the main character.
Okay. Okay, that's important. So if the story is the same and they just changed the name, and you can see that there are a lot of similarities between the two, what I would suggest is that, of course, in the case of, if we're discussing about a school project, you can report that to your teacher or to the person who assigned this task to you, and you can actually report it, and later on, as we saw earlier, you can prove which of the two were created first, provided that you have all the early versions and all the versions available from the beginning, so that you can prove that I created that essay, I wrote it first, that is what that was my idea of the story, documented on that date and that time precisely. You two can then compare which of the two created the work earlier, and then you can resolve anything that might come after that. But this is actually why it's important to have everything documented. And also, it's very important, if you believe something is important to you and that it will matter later on, it's better not to share it in advance. Because as I explained earlier, ideas, when I express my idea through a discussion, that cannot be protected. And of course, anyone can go on and steal it from me. But still, if they created the document first, you cannot do anything. So it's better to keep a bit of a privacy for yourself until you write it down. And then you have all the proof that what you created is yours because of the date, because of the time, and because you can prove it. I hope that this is clear, but of course we will come back to it because I actually have that I had that in mind in advance, and I prepared an example for you in the following slides. Oh, actually here we are. So yes, what could be done in the scenario where a school project is being copied? So your question was on spot, because actually what you can do is what I just mentioned. I will repeat it in case something was not clear before, or in case you would like to ask something further on that point specifically. So first of all, is to compare the two projects calmly. You just compare whether they are indeed similar, how similar they are, whether they used the exact slides or text, design, and whether they are almost identical. For example, now that you mentioned that the names were different, but the exact story that you created was the same, then that's a problem. And of course, here you can just say that, yes, it's almost identical, just the names are different. So if the similarity is only in the general idea, then both persons or both teams may be allowed to continue. Because as we said before, like with the story with the flying elephant, the idea of the story is the same. You have an elephant that is flying, but then each story that will be written down, each separate story that is created out of this concept, this is what is protected. So if the actual text, diagrams or design have been copied, that it's important to talk to your teacher or your mentor or the one who assigned the job. You show them the early drafts and the files with the dates and times and whatever information and details that you can get. I suppose most of your job now and most of your projects are through electronic means, for example, PowerPoint or Microsoft Word, where you can actually get access to that details of when you created the first draft, when you last saved it. So you get that information, and technology now helps a lot. So use it. And for the future, teams can protect themselves by saving all that drafts, as we mentioned before. Even the earlier draft that you have available, you should have it at hand, and you should keep records of what you did and when. So the answer here is likely depending on whether the idea per se is similar or whether the actual expression of it has been copied. So I hope this is clear, but if not, I'm here, use me.
Yes, I wasn't clear. Thank you.
You're welcome. So just a few more comments on the practical tips to protect your creations in general. I'm not only referring to school projects here. So save everything. I can't stress that enough. Save everything. Keep your files, early drafts, sketches with dates. If something is documented in a non-electronic format, have the date on it, have your name under it. Something that can prove that something was created on that date. If you create a logo or a name for your project, keep a record of when you first used it. Share the full details of your project only with people you trust. And this is important because we mentioned earlier that ideas are not protectable. So you should be cautious of who you share information with, only with people you trust, or in very, very controlled spaces. For example, you can share an information or an insight with your teacher because it's the one who assigned the job to you, assigned the task, the project. But it's better not to over discuss your ideas with other students because they might copy it. And if one day your project becomes a real business or a real product, you can look at the formal protection process through a lawyer, a legal consultant, or someone experienced on that field. For example, registering your trademarks, your patents, your designs. There are many tools and many ways to protect each creation, let's say. There are different routes to protect it, which I'm not getting into detail now because most of them are technical and I don't want to bother you about that. You don't need to think and you don't need to worry about that. Keep the lawyers to worry about that. Just have in mind that if you have a creation that you believe that it will become important in the future, or it will be part of your business that you will be selling, then consider consulting a legal expert on the field, and they will guide you. unless you become a lawyer yourself. You can check that out. Now, let's pause at this point and reflect. Think of one thing you have created and you are very proud of, like drawings, perhaps a song, a story, a presentation, a TikTok video, a mini business idea, anything. Just think of it and ask yourself, is it written down, saved, and recorded somewhere that you can find it easily? Can someone else easily has access to it? And perhaps what kind of IP type of the 4 IP tools under the general umbrella that I mentioned fits better to that case? Is it the copyright? Is it the trademark? Is it a design or is it a patent? Just think of it. It's interesting because I'm sure you will think of something that you have created. As kids, we create a lot of drawings. My mom, after 30 years in my life, I still find drawings that I drew for her when I was a kid. Actually, that can be protected. And who knows, maybe I will become famous for it and get paid. Small Picassos. So, in general, I want you to have in your mind very, very clearly that your creativity has real value. We are in a world, we live in a world where creativity is a key, is the key of success. So don't underestimate your work, don't underestimate your ideas. Go on, express your ideas, document them, and be very confident about them. And when ideas can become protectable when you turn them into something concrete. I often connect this with the saying, actions speak louder than words. Actually, it applies here as well. Actions, writing something down, speaks louder than simply sharing an idea with a group of people. And this is where the protection lies, expressing your idea. A word in the air, it could be taken by anyone. It could be misinterpreted. It could be wrongly used in a way that you wouldn't like it to be used. But when you express it, when you act upon it, and when you act upon something, that's different and it stays. And no one can change that. So Yes, the third point is that different creations use different IP tools. The copyright, the trademark, patent, design rights, and of course, as we have just seen with the example of Toblerone, a product might get protection under more than just one IP right. You can have multiple protection under a single product, and that's very often. For your school projects, of course, and any other project that you are working at, the most important things are documenting your work, respecting each other's work, because if you want your work to be respected, you need to respect others as well. It's like karma, if you believe in karma. You should communicate openly if you feel something that has been copied. I mean, calmly and in a logical way. And I'm sure that your teacher and your fellow students, pupils will realize what was going on and whether there was a copy or a stealing of your idea indeed. In that case, you will handle it accordingly. But in any case, you should remain calm and you should process this, and you should go on with this process with respect to each other and with an open discussion. And if you ever feel unsure, you can ask, now you can ask your teacher or someone you're working with, your mentor, or the one who assigned your work. But later on, there are lawyers outside, the legal consultant, you can consult them, you can approach them, you can ask for an advice, and they will be more than happy to help if they do have experience in the field. If not, they will refer someone who has. So, actually, this is it from my side, a basic overview of the main types of IP rights, how you can protect your documented ideas, and what to have in mind when you create something. So you can feel free to ask me anything. And just a small note before closing, that I honestly, truly believe that you have all the skills and the passion and the power to create something magical in your lives. You're here, you're watching me, you're interested into expanding your knowledge and into knowing how to protect your ideas. And by being in this overall program, the FEM program is really, really inspiring. And I'm sure that you will get really, really powerful skills for your future. And by being here, it means that you care. And that's the first step, to care. So I have one assignment for you. It's a really tough assignment. I'm talking about a real homework, and that's not completed in 1 week or in 1 day. It's an assignment for a lifetime. So I want you to believe in yourself, believe in your capabilities, and don't get me wrong, I don't mean it in an arrogant way. You should always seek for guidance and improvement, but with total trust in yourself about what you can accomplish, about the value of your ideas and the power that you have within. So never forget that. It's your assignment forever. It's your forever assignment. And before going to bed, I want you to remind yourself of that. You're capable of anything. Just believe in yourself. So thank you so much for listening. It was a real pleasure sharing an insight of my knowledge on that field. It's actually the basics, but the basics are usually the beginning of something. So if you know the basics, you know that something actually exists. So if anyone wants further guidance or you need further details or explanation, or if there's something you didn't understand, just reach out. Inessa has my contact details, so you can send me over an email or even call me. I'm available for you anytime. Preferably not during midnight, please. You can text me during midnight, but I won't answer a phone after 12.
Rita, so be prepared to have a lot of calls and emails from our participant. And I want to say you thank you so much for the today's session. And I'm sure that everyone who joined and even who will listen this session in offline and recorded later will find it super, super useful and inspiring.
Thank you, Inessa. Thank you for the invitation. It was a pleasure, and it was an honor to be part of this program and this initiative. So it's all my pleasure. Thank you so much.
Thank you. All here's for you. Bye. Bye.
Bye now.